Hello, my name is Barbara McDonald, Professor Barbara McDonald from the University of Sydney Law School, and I'm going to talk to you today about a source of law in the Australian legal system. I'm going to concentrate on the source of law that we call case law, or sometimes we call it the common law. So first of all, what is case law? Well, case law is, as I said, a major source of law. Sometimes it's called the common law. It can also be called judge-made law. The other major source of law in our legal system is legislation made by Parliament, which is sometimes called statutes made by Parliament. A case involves a court, that is a judge or possibly judges, determining a dispute between particular parties. Cases lead to a judgment by the court made up by that judge, which sets out the facts, it sets out the law relevant to those facts, and then sets out the court's decision. Let me take each part of the case in turn. First of all, let's look at the facts. First of all, the court has to decide on the facts, and to do that, parties and witnesses will give statements in court, or perhaps they might produce other evidence, such as video footage of events, recordings of what people say, or usually documents about perhaps what the parties have agreed or other relevant matters. The court may have to decide on a version of the facts that it believes the parties might be in dispute on the facts, and the parties have to prove the facts to the relevant standard of proof. If it's a civil case between A and B, a private dispute, they have to prove their facts on the balance of probabilities. More probably than not, what happened. Whereas if it's a criminal case where a person is being accused of a crime, the prosecution has to prove the facts beyond reasonable doubt, a much more onerous standard of proof. Once the court has heard all the evidence, the court finds the facts which it says have been proved. Secondly, a case, the judgment in the case, will set out the law. So the judge will describe the existing law that is relevant to the facts as proved. The existing law is made up of either the common law or statutes and legislation that are in force at the time, or a combination of both. There may be some common law aspects to the case, some judge-made law relevant to the case, and there might be some statutes relevant to the case. The common law also includes cases interpreting statutes. So once a statute has been made, let's say in the year 2002, we're now talking in 2019, there will be 17 years of cases that have interpreted that statute. And those cases may go all the way up in the court hierarchy. The judge will explain the principles of law that are to be found in earlier judgments or in the legislation. And then when deciding which legal principles apply to the case, the judge or the court will be bound by what we call the doctrine of precedent. Thirdly, the court or the judge or judges, if it's on appeal, apply the law to the dispute and they reach a conclusion of law. The judge gives a judgment for the party who brought the claim, who will be called a claimant or a plaintiff, or may give judgment for the other party, who will be called a defendant or a respondent if it's a civil case. If it's a criminal case, we might call the person who brings the case a prosecutor, and the defendant is an accused person in such a case. Now that judgment will bind the parties to the dispute, and only the parties to the dispute, in terms of what it actually decides, but it might have value as a precedent for similar cases in the future. Once the judgment by the judge is given, either party can appeal from that judgment to a higher court. Sometimes they require leave to appeal in order to continue an appeal. In other words, the higher court will look at what cases it will accept on appeal. It won't take them all. It will only take cases that it thinks are very important or that indicate some miscarriage of justice at the earlier stage in the proceedings. Courts of appeal are more senior courts, and they sit with 3 or 5, or sometimes in the High Court of Australia, even 7 judges to hear the appeal. And the appeal court gives the decision by a majority. Whatever the majority of that number thinks is the conclusion is the binding result in the case. Now let's talk a little bit about the doctrine of precedent. Sometimes this is also known as the doctrine of stare decisis. The matter stands decided, with the Latin term being used to describe it. But mostly we talk about the doctrine of precedent. And this doctrine holds that courts are bound by the previous decisions of law made in their own court, their own level of court, and in more senior courts, and by decisions of other courts in the same level of their legal hierarchy. Stare decisis essentially means the thing, the matter, the issue stands decided. The law on this matter has already been decided in a previous case. This court, in this case, doesn't need to work out afresh what the law should be. Now, there are several levels of courts in the Australian legal system, and to understand when a particular court is bound by decisions of another court, you need to understand the legal hierarchy of courts in Australia. But at this stage, let's just remember that the highest court in Australia is the High Court of Australia, which sits in Canberra, our national capital, and it hears appeals from all courts throughout Australia, whether they're state courts or federal courts. Now, you won't really be able to work out the doctrine of precedent that applies in your particular case until you know which hierarchy, where in the hierarchy your court is situated, and you will learn about the court hierarchy in another session. But essentially, what you do need to know is that all courts in Australia are bound by decisions of the High Court of Australia. Why do we have a doctrine of precedent? Why don't we let courts decide what the law is afresh every time they hear a particular case? Well, the doctrine of precedent, or stare decisis, has many advantages, it is said, including, first of all, consistency and equality before the law. You will learn a lot about what we call the rule of law. And a basic principle of the rule of law is that everyone should be treated alike. That's the first advantage and benefit of the doctrine of precedent. The second great benefit of it is efficiency in time and in cost. It would take a lot of money for parties to have to argue afresh what the law should be in every single case. Cases would take much longer, they'd be much more costly, and it would be very inefficient. Thirdly, and this is also very important and an aspect of the rule of law, the doctrine of precedent allows people to predict and to know with some certainty what the law is. What are their obligations? What are their rights under the law? What remedies are they entitled to? When will they be found to have breached the law, if it's a criminal law? What is a court likely to decide in a dispute? Now, obviously, that's not an exact science. If we could always predict exactly what a court was going to decide, there would be no cases, no litigation in courts, and there'd be no appeals because there'd only be one answer. Now, here's a diagram on this slide which gives you a little bit of an idea of how the law develops when it's looking at a case and looking at the doctrine of precedent. In order to find a precedent in a previous case, you have to be able to identify the reasons, the legal reasons for the decision in that case, because it's only the legal reasons that are binding on future courts. The legal reasons are called the ratio decidendi, and again, another Latin shorthand term for the reasons for the decision. And I can tell you that it can be very, very difficult to determine what were the exact legal reasons for a decision, because you have to read the case carefully, you have to decide what is relevant and what is irrelevant, what is not relevant to the actual dispute between the parties. It is a skill that you will learn, and it is a skill that lawyers continue to learn throughout their career when they're reading a case, identifying the ratio. Now, sometimes judges make comments about the law which are not actually necessary for the dispute in the case. So, for example, they might think about, well, if the facts were different in this way. In other words, what they're really doing is talking about hypothetical rather than real facts. And if they make comments about what the law might be in those situations, they're really just giving incidental statements, which are known as obiter dicta, something that was otherwise said. Obiter dicta, statements by the court which are not necessary for the decision, are not binding on other courts. Even if it's in the High Court, the obiter dicta are not strictly binding on lower courts, although, of course, you always read carefully what the High Court says in obiter dicta, because it might be persuasive. It would give you an indication of how the High Court might decide a particular case. But the High Court can change its mind on that issue when it has real facts before them. Now, when you're reading and analysing a case, you just need to be clear about who is who. A case is known by the names of the parties in the dispute. In a civil case, the name of the plaintiff, the one who's bringing the case, comes first. Mr. Smith will sue Mr. Jones. And in that case, the case will be known as Smith and Jones, Donoghue and Stevenson. Note how it's actually Smith versus Jones with a V standing for versus, but we tend to say Smith and Jones, Donoghue and Stevenson when we're reading it, but we'll write it Smith v. Jones. If there is an appeal, the appellant's name comes first. For example, a very famous case that was brought to the House of Lords in the UK back in 1932, one of the most famous cases in the law is the case of Donoghue and Stevenson, which was a case brought on appeal by Mrs. Donoghue all the way to the top court of the land at the time, the House of Lords. In a criminal case, the case is usually known as R versus Smith, with R standing for the Crown or the government in the particular state or territory or legal entity. R actually stands for Rex or Regina, the Latin name for the king or queen. Now remember that judgments can be very, very long. A legal skill that you will learn is how to read judgments quickly in order to identify the key facts and the points of law and to understand how the judgment adds to the existing law. Thank you for your attention, and I look forward to welcoming you to Sydney Law School. Perhaps I'll meet you in Foundations of Law, which you do as your first course when you study law, and I look forward to seeing you there and perhaps in some other courses later on in your degree.